asbestos really did cause immense harm. And the company closed its English factory, Barking factory, in 1968. It still continued to operate its mines and mills in South Africa until 1979. And we became instructed and commenced proceedings again in the English court, so again against the parent company. The subsidiary companies were insolvent. There would have been no point seeing them. There was no insurance in place for them, certainly none that we were aware of. And again, from the investigations that we made, we felt that there was sufficient evidence to hold the parent company again directly liable for what had happened on the ground. In this case, there were very protracted forum non-convenience proceedings. The company very much wanted the case to be brought in South Africa. Arguing on behalf of the claimants, I know somewhat controversially, we argue that the case should be heard in the UK. Again, the claimants were in receipt of public funding, which meant that we could get access to the medical experts, the technical experts that we required to be able to fight on an equal footing. And over time, legal aid wasn't available in South Africa for these sorts of cases, and again at that time there wasn't a group structure available. There ended up being 7,000 claimants, and we argue that the time it would take to coordinate all the cases would mean that potentially a lot of people could die during that process or not get access to justice. And in the case was up to the House of Lords, the UK then House of Lords, now would be the Supreme Court, on the issue of forum. And the South African government actually intervened, again, possibly considered somewhat controversially, or actually saying that they also supported the idea of the cases being brought in the UK, that the new South African government could not deal with all the legacy problems of apartheid, and its courts shouldn't be overwhelmingly burdened with all these actions. And the House of Lords did unanimously hold that forum should remain in the UK, essentially because there would not be, it accepted that there would not be adequate funding for all of the cases to be fully litigated with sufficient funding in South Africa. And the case, again, as a lot of these cases tend to do after certain key issues are resolved, did eventually settle as well. Turning now to just briefly a claim that we brought against the British government for actions allegedly committed overseas, not justifying the principle to British multinationals. We represented over 1,000 Maasai and Samburu pastoralists from Kenya earlier, it was in the early 2000s, who argued that the British Army, who had been practicing their training exercises, conducting some of their training exercises, using live ammunition on their pastoral ranges, had negligently left many unexploded ordnances on the ranges, which contrasted to their exercises back in the UK, and also on occasion where they did use the land of white ranchers in South Africa and in Kenya, and did very thorough clean-up jobs. The clean-up jobs that they did on pastoral ranges was very inferior. And these were ranges traditionally used by the Maasai and Samburu, in particular the children, for their cattle. And often, as we heard again, taking many testimonies from the clients, would often see little trinkets, little things that they felt that they would use for adornments, which actually were bombs. And there were many cases or even their cattle would just step onto these unexploded bombs as they walked across the land, resulting in many fatalities, many severe injuries, and to a people who were also very marginalised within their society who had no sufficient access to medical care. I remember meeting a very old Maasai man who'd been using a tin can for a foot for half a century. So people with lost limbs, severe burns, shrapnel injuries. And again, we were able to bring the case in the UK because it was against the UK Ministry of Defence, so they were allowed to bring the case in the UK as of right. In that case, there was not a big forum argument. Possibly the government felt more comfortable being sued in its home courts than another court, but they certainly didn't raise that, which made the process a lot faster. And again, it was a case that then settled out of court, and by way of mediation, which I understand as being more used and introduced into the Indian courts. And from our experience in quite a few cases, it's been, well, it seemed to us as lawyers, obviously can't speak totally for our clients, but from the outside it's quite an empowering process. Some of our the clients came over. These were people who, some hadn't even been to Nairobi, let alone ever stepped on an airplane, and crossed half the world, as well as community representatives were able to come and say their stories to members of the Ministry of Defence and actively participate in negotiations. They were clear at each stage what was going on, what was being said, and what the arguments were. And it was also a case where, quite unusually, normally as lawyers and as litigators, our role ends when you sort of send a cheque to the client in that quite crude way that you do with monetary claims. But here, a lot of people who hadn't had access to treatment wanted us to help arrange to get prostheses for them, arrange surgery so that shrapnel was removed. A lot of the kids wanted help in getting into schools, and it was, I guess as a lawyer, it's one of the most heartening cases that I've done, where you can see the impact that the damages did bring. Moving then quickly on, changing continents to South America, as Richard said, we've acted for a number of farmers in Colombia who have one wave of cases are settled and another is still ongoing, which Sudhanshu there is instructed on, who are bringing an action against BP for damage allegedly caused to their land by the construction of a pipeline. These were farmers in, again, quite a remote region of Colombia, quite a dangerous region of Colombia, as a lot of regions are, who had suffered major damage to their crops, to their ability to fish. Some of them had gold mines as well, small gold mines on their farms, which had been damaged by the BP pipeline. Again, there was sufficient evidence to link it with the parent company and an English company that had actually entered into some contracts with the clients to compensate them for damage to land, but where we argued that those contracts had not been honoured. Again, the first set of claims ended up mediating in Colombia, with the whole mediation taking place in Colombia, with the mediator coming out there as well. The second wave of claims is not being mediated yet, may still go to trial. And it's a case where now the company BP is fighting very hard, and where we're having to instruct a whole range of experts in geology, hydrology, agriculture, pisciculture of the fish. So a huge range. I've probably missed out half a dozen experts there. And it's also a case where we're no longer funding such actions with legal aid. The legal aid budget in the UK has massively shrunken over the years, as have the sorts of cases that do get legal funding. but we're able to do these cases by way of what we call conditional fee agreements, where the clients don't pay anything if they're not successful, and if they are successful, we recover costs from the other side. It doesn't come from the client's damages. And I know, running out of time, very briefly, just again to touch on the Trafigura case, the Ivorian case that Richard also mentioned. This concerned or arose out of the dumping in 2006 of a whole load of oil waste, which had been treated with caustic soda, giving rise to a rather toxic mix, which was dumped by an oil shipping company in Abidjan, in the Ivory Coast. The company had tried to get the oil waste treated in Holland, but had not wanted to pay the very high cost that was being charged when the authorities in Holland realised that the contents of the waste. It then travelled via the Ukraine and Nigeria, I think, until it eventually got to the Ivory Coast, in which time a very small other company had been set up that it then contracted to dispose of the waste, which this other company did by just dumping it around Abidjan, sort of literally all over the place at night, over a sort of series of a few nights. And in the days and weeks that followed, as Richard said, 100,000 people ended up going to hospital complaining of vomiting, diarrhea, sickness, headaches, flu-like symptoms. And over the course of the next two or so years, we ended up being instructed by just over 30,000 Ivorian clients, and it was a process of taking the direct instructions from the clients in a whole series of site visits. Again, this sort of case would only be possible with the group structure that we have in the UK that Richard would talk about, where you proceed by way of test cases, and not all the cases are litigated. Again, it was a case that involved a whole host of experts in toxicology, epidemiology, psychiatry, health, chemistry, and a huge range of experts. Again, to be able to try and fight at least at some, I wouldn't say it was a totally level playing field, but trying to level the playing field a bit with what we were facing with this massive opponent. And just a month before the case was due to go to trial, in October 2009, the case did settle. And again, we had the interesting process of going out and getting instructions from 30,000 clients back in the Ivory Coast to accept the deal. We weren't prepared just to agree to it on their behalf. So there are other cases I could talk about, but I know that time is very tight. So that's a flavour of the sort of action, the sort of environmental litigation, environmental stroke health litigation that we've been bringing over the last decade and a half, using what essentially are quite simple tort arguments to try and hold companies and the state to account where it has not applied the same standards abroad as it would apply to its own citizens. I think we're okay, maybe. Okay, over to Richard.
Just talk very, very briefly. Time is limited. Just a little bit about the theory and the thought behind these cases from the human rights perspective. English law, from the human rights perspective, is extremely well developed in respect of public law, governing the relationship between the individual and the state, and that's only been enhanced by the introduction of the Human Rights Act. And similarly, international law, although very weak on enforcement mechanisms, is extremely eloquent about the relationship, the obligations of nation states to individuals. which is unsurprising for instruments that were developed in the long shadow of the Second World War, that one would be worried so much about the rights of individuals. What neither public law, by its very definition, nor international law address is to some degree, the New World Order, where what is not only important is the relationship between individuals and the state, but the relationship between individuals insofar as their lives are impacted by large multinational corporations, which in many instances can have a greater impact on people's lives than their own governments, and in some instances can be much more powerful. To give an example of the Ivory Coast case, the company, the defendant, Trafigura, their annual turnover was twice the GDP, 2.5 times the GDP of the Ivory Coast itself. And so there has been a frustration, or historically a frustration, from those engaged in human rights about the inadequacy of redress mechanisms for victims of human rights where there are allegations that they've been caused by, either directly or indirectly, by multinationals. And when I say redress, I think from a human rights perspective, I'm talking about two main things. Firstly, I'm talking about a remedy that is available to a victim, and secondly, I'm talking about a mechanism of accountability. And it's those two together that are often very important for a victim of human rights abuse. So these claims really need to be seen in that context, which is a degree of frustration about the inadequacy of public law remedies and international human rights instruments providing forms of adequate redress. And so what lawyers, not just in jurisdiction in which I operate, but in other jurisdictions have done, is really grab hold of an area of law that traditionally human rights lawyers thought of was rather grubby, which is tort law, the simple law of compensation, and started to try and think through the principles of tort law, dust it down, and to try and apply it to these forms of situations. And really, a lot of the starting point for this kind of work started actually in the United States, where they were helped by actually having a statute that enabled them to do it. Many of you, I'm sure, would have heard of the Alien Claims Tort Statute, which enables an alien to bring an action for tort before the courts of the United States where there has deemed to be a violation of the law of nations. It was actually a statute passed by the very first Congress in 1789, but nobody really used it until the very late 1970s, when it was used by human rights activists, not in this context, but in a more direct context of seeking redress for people who had been tortured. The very first case was against the Paraguayan colonel. But quickly, human rights activists in the States started developing this in the corporate context, and they started arguing that it wasn't only individuals who could be held liable, but corporations who could be held liable. And there have been several very big cases that were brought there, quite inspirational cases. I'll give you two examples. One is a case called Doe and Unical, which was a class action brought against a Californian-based oil company for their involvement in the construction of a pipeline in Burma, in which it was alleged there had been complicity with junta, including the use of child labour and forced labour. And again, shortly before trial in that case, having established along the way of very interesting decisions of the Ninth Circuit, the Californian Circuit, about the way in which corporations can be complicit in human rights abuses, the case settled. Another case that settled more recently was a case brought by Agani people from the Delta area in Nigeria against Shell, including the family of Ken Saro-Wiwa, the poet who was killed, in which it was alleged that Shell, the oil company, were complicit in the repression of the Agani people. And again, shortly before, in fact on the eve of trial, that case settled. So that litigation has been going on for many years, and it's taken, well, from my perspective, would be a very unfortunate turn in two recent decisions of the Second Circuit and the Ninth Circuit questioning whether or not, in fact, the law of nations applies to corporations. And it remains to be seen whether the Supreme Court will take those cases on its docket, what will happen to other litigation that's pending, including the South African apartheid litigation that's pending for it. But that's how it developed in the States, from which there was some inspiration taken in the UK, where we don't have a statutory basis in the same way that they have the Alien Tort Act. But what we do have are centuries of common law and the use of tort law. And it's that we have used, applying exactly the same principles as we would apply. I know it's different in this jurisdiction, say for a straightforward car crash, in some cases, in fact, you have a statutory scheme. But the same sort of very basic principle about saying to a defendant, you expose me to a foreseeable risk of harm, and it's just and reasonable that you compensate me for that harm to which, in fact, occurred. So taking very simple principles and simply applying them on a larger scale with a larger number of people and a different set of facts, be it environmental damage in the Ivory Coast or Colombia, or be it torture of environmental protesters in Peru, and cases concerning not only environmental damage but the removal of what I know in India and other parts of the world is the essential link between people and their land that often happens in cases of this nature. Can I just talk very briefly about 5 aspects of how these cases work in theory and in practice? Firstly, judicial management, how they're managed by our courts. Secondly, the issue of jurisdiction, Satton has touched upon. Thirdly, the one really key, meaty issue of law that arises in these cases, which is holding a parent company liable for the acts of its subsidiary. I then fourthly want to touch on costs. I'll keep Joshua's 2 minutes per subject. And finally, I just want to look into the future as to where these cases go. And just to describe it so that you can take what you want and leave what you want, where it might be relevant to the Indian experience. Let me start with judicial management. Many of these cases involve extremely large numbers of claimants, but our domestic courts have become quite used to managing them in a central and efficient manner. In late 1990s, we introduced our new civil procedure rules following Lord Wolf's review of civil justice. And as part of those rules, there's a particular section that we've included in your papers that deals with the management of large group claims. Had a number of levels to it. In short, the court has to certify that this is a case that is suitable to be group litigation, or issue a group litigation order that in fact has to be approved by the head of the Queen's Bench Division. And they will do so when they recognise that there are issues that are generic to all the cases, the disposal of which is going to be an efficient and just way of dealing with the case. When a GLO is made, you will be appointed a judge who will deal with all case management. Every decision that judge makes will be binding upon all the group. And then when you go to trial, instead of calling 30,000 clients, which would have some considerable implications, you pick lead cases that are representative of the generic issues, and the findings in those generic cases will bind all 30,000 or 300, however many you have in your group. It is similar, but with some marked difference to the US class action system. So that's how we manage it, and it's extremely efficient. The incident in Abidjan occurred in 2006. Ivory Coast is one of the most dangerous, with all the news and now sadly lawless countries, and we were able to get it to trial that was due to commence in October 2009 with 30,000 people, and that was due primarily to very firm judicial management. Jurisdiction traditionally used to be an enormous problem, as reflected in the American jurisprudence under their act, and we would always be faced with arguments that London was not the appropriate forum. European law has risen to the rescue because now the European law, where we can show that the defendant headquarters is domiciled in London or England or Wales, we can prove jurisdiction as of right. And there was a case from the European Court of Justice we included in your bundle that demonstrates that. So in a host of recent cases, forum hasn't even been argued by the defendant. Liability of the parent company for the acts of the subsidiary is a topic on which can take a week. But it is a very big issue, because, not least because of the way in which modern multinational companies operate, which is that you will very rarely see one large headquarters operating in an underdeveloped country. What you'll more likely see is either a wholly owned subsidiary or a majority stakeholding, often with the local home government. And what we have had to face in numerous cases are arguments about the corporate veil, saying, well, this was the local subsidiary, it had nothing to do with headquarters, which strikes a chord with all of us who have studied commercial law. But the way that we have sought to get around it, at least one way we sought to get around it, as Satner said, happened in the Cave case, is to argue that in fact a parent company, particularly when operating in a dangerous part of the world or an undeveloped part of the world, owes an obligation to ensure that standards are met by its subsidiary. Now that is yet to be argued before court, because in all the cases in which it has arisen, the defendants, rather than seeking to baffle it, have chosen to settle. But undoubtedly, it will be an issue before the courts. Can I then turn very briefly to the question of costs? And I raise this because I mean, not least having talked to Colin about public interest law in India. It's an issue that really is very important in terms of the UK, in terms of being able to bring these cases. I mean, I know that in India, it's very difficult, if not impossible, in public interest litigation, for a successful claimant to recover their costs. I mean, I have to say that we've had an enormous amount of public interest litigation in the UK, some of which has been fueled by non-governmental organisations who do it for free, but I shudder to think, if we'd been in the same situation, I know that Colin finds himself in actions against government, how far behind we would now be. But in this area of the compensation claims against multinational corporations, the rule that we have, that the loser pays, is the only basis on which these cases can go forward, because they cost an enormous amount of money to run, because the other side is, almost by definition, extremely well resourced and throw absolutely everything at the case. And unless there is a prospect of recovering the outlay that it takes, then these cases are simply impossible. To give an example, I mean, Satner's firm in the Ivory Coast case, we're not only dealing with an incredibly well-resourced defendant, but had to meet the costs of experts, of having a team of up to 60 paralegals to go out and deal with 30,000 clients. And so the cost regime in England and Wales undoubtedly has some major flaws in it that one of our Lord Justices is currently reviewing, is nevertheless an absolutely essential basis for allowing access to justice in these types of cases. Lastly, the future. There's no shortage, unsurprisingly, of these types of cases, and in fact they get more interesting as time goes on, because one now looks not only at the role of subsidiaries, but more interesting issues that I know would arise in this jurisdiction about liabilities for those who project finance big projects. The more interesting issue, though, is that I would say, as someone who's been involved in these cases and bringing them in England, one of the much more hopeful things for the future is that there will be no longer a need to bring them in England. And we've seen that, for example, in the Southern African example, where we would never dream of running an argument now that South Africa can't deal with these cases, and indeed is dealing with these cases. but I think it might yet be some time before cases, for example, in the Democratic Republic of Congo or Ivory Coast or other places around the world are going to be brought anywhere other than effectively than a third-party jurisdiction. So that's a very, very brief, I'm afraid, very superficial overview of the cases that we've been bringing. And I hope that one of the reasons that Colin wanted us to come and talk here is because we've been dealing with situations, albeit one step removed, of the type of problems that are caused to very many people by the activities, for example, of these extractive industries, which I know is a big issue here. And I know the courts have been grappling with issues such as Vedanta here. And I just hope an insight as to how we've been very much on the fringes of dealing with the real problems that you have to deal with. I hope that in some way there's something to be gleaned from our experience. Thank you very much.
Thank you, Mr. Richard and Sapna. In India, we have two illustrations. One in Union Carbide case, with Shriram chemicals. In Union Carbide case, when it was a class action, mass destruction of human life, the government took over the responsibility, and that legislation was upheld, and ultimately entered into a settlement. From your talks, very illustrative and very encouraging talks, I found that in these class actions, mediation would be a possible answer for ending a long litigation and for long evidence to be led, and the inequality factor between the claimants and the... But for that we need some legislation and very strong precedents. We are running a very successful mediation center at Allahabad. But when the talks come to a point of settlement, then the strong judgments of precedents help. If we have a very good and strong precedents of environmental damage matters, then certainly these matters can be solved with the help of a mediator quickly, and that would bring in good relief. Mr. Sudhanshu from Human Rights Committee of the Bar Council of England and Wales will now initiate the discussion.
Thank you. In response to the presentations by Sapna and Richard, I want to explore the question of whether the tort model which they talked about is a panacea, whether it is the answer in all cases, or whether it has certain limitations. My suggestion, and after this I want to throw it open to the floor, my suggestion is that it is a very important tool in holding corporations to account, but it is not a panacea. Based on my experience in these cases, including the cases that Sapna and Richard have talked about, I suggest there are 6 advantages that I can see in the tort model compared, for example, to the public interest litigation model that I understand is more prevalent here in India. The first is this question of jurisdiction. The transnational tort model allows a claimant in a country such as Colombia or Ivory Coast, in a case where the facts have nothing whatsoever to do with the UK, to come to the English court as of right if the defendant or the relevant corporate entity is domiciled within the meaning of European law within England and Wales. And that is incredibly powerful, particularly in the light of the new European law that Richard talked about, because you don't get costly preliminary arguments about discretion. It's a matter of right. Nor, interestingly, do you have to establish that there is any public interest. Indeed, in those cases that Sapna and Richard talked about, there would not be any public interest.
Led the previous government to introduce an inquiry by a distinguished Court of Appeal judge. Now, in the current period of austerity, I would not expect, where we are trying to cut down litigation and make it harder for cases to clutter up the courts, however meritorious, unnecessarily. I have to say that I would not expect this imaginative tort jurisdiction to go unchecked by other considerations of the UK public interest, because it's very important that access to our courts, whether they're by foreign, transnational or UK claimants, are proportionate and costs are really kept down. One example is mentioned already just now in the defamation field, where again there are gross abuses, as the European Court decided last week in the context of libel proceedings. And I have no doubt that in the reform that I'm partly responsible for as a member of the government, I have no doubt that we will find means of driving down legal costs, even though I have to say that the legal profession will scream with pain, and I believe it's justified that they should. Thank you very much.
We welcome my Lord Justice Asdamat Kabir to this session. He'll be leading the next afternoon session. It was a very thoughtful.
May I ask one question?
Yes.
Now, this mass tort action basically in India, I think we have, is still not in that developed stage. But one thing we have done is the concept of parents' patre has been followed, that was followed in Bhopal and these are chemicals, Sivan chemicals. The measure of damages which the issue goes into, what is the test of the measure of damage that are applied? Well, as far as India is concerned, we have the claims tribunal of death, loss of limb, workman compensation, again death, loss of limb, ESIS, hospitalization and payment for non-work. What is the test of measure of damage that applied while granting these claims?
It will depend slightly on the type of case. Where someone has sustained injury, let's say as a result of exposure, you'll get two types of damage. You'll get what you call general damages, your pain and suffering, which are assessed by reference to other cases and judicial guidelines. Traditionally, up until really now, even if a case concerns someone sustaining damages in the DRC, you assess those damages by UK English law standards. That's about to change because of changes in European community law, so it will be assessed by the standards of the home state. The other element of damages you get are damages for your financial losses. So, Colombia case, you look at what the cost of the loss of land was, use of your mines, use of your crops, you apply it to whatever situation. So it's normally those two types of damages that you get. What you don't get, I mean, just for 1 second, what you don't get with tort claims, which, as I say, are very much a crude tool to use. No one's suggesting for a moment it's the perfect thing to do, but what you don't get is what you get from mediation, which is something I was saying can be just the most powerful tool. I mean, sometimes it doesn't work. But if I can give one example of mediation slightly out of context, which is the case that Dave Sattler's firm brought on behalf of some Iraqi men who had been tortured by the British Army, one of whom died as a result of his injuries, and there's been a public inquiry looking into his death. And this was a tort compensation claim brought on behalf of the father of the man who died, a man called Bahar Musa, and the other men who were with him when he'd been tortured. And tort claim is a very crude way of trying to deal with this case. And what the government offered in this case was a mediation as an alternative to going to court. And I can't think of a more contentious case. A father, his son had been tortured to death, people who had been sustained horrendous injuries at the hands of British troops. Yet over the course of 2 days, at which the second in command of the British Army came along in uniform, to apologise to the men, to give them a written apology, in which the